Here.
Representative Western. Representative Yin.
Here.
Mr. Kaufman.
Excused.
Ms. Long. Here. Mr. Reville.
Here.
Co-Chairman Rothfuss.
Here.
Chairman Olson.
Here.
Mr. Chairman, you have a quorum.
Fantastic. With that, let's jump into our open banking updates. Representative Western, do you have any updates that you would like to speak to on open banking?
Nothing I haven't already. Mr. Chairman, nothing we haven't already iterated before in terms of the concept. I know it's still broad. There's still a lot of unknowns. I do really appreciate the Banking Association, their willingness to be a part of the conversation and contribute. Again, I think that there's a lot of potential to be had here, and I think it's as much about the substance of the policy as well as just sending the message to the industry, to these APIs that, hey, we're welcoming, and combined with some of the banks that we do have here, these SPDI banks and these other digital asset institutions, I think that there's just a lot of potential. I almost kind of view this akin to 2018, 2019, when we were trying to wrap our hands around some of this crypto stuff. We weren't exactly sure what it needed to look like in terms of the language, but we knew that there was a lot going on and a lot of potential. So that's kind of where I'm at, Mr. Chairman.
Co-Chairman Rothfuss.
Thank you, Mr. Chairman, and I apologize to everybody for my voice today. It doesn't seem to work like it's supposed to, but it'll hopefully hold out. We'll see. We did have an opportunity through the last Minerals Committee to work the bill that was recommended and forwarded from our committee to the Minerals Committee. As the committee will recall, banking bills have to be forwarded to the Minerals Committee by our original charter legislation. So at our last meeting, we recommended forwarding our draft legislation that we worked with the Division of Banking on. That went to the Minerals Committee, and it did pass the Minerals Committee. So the Minerals Committee is sponsoring our bill unamended, if I'm not mistaken. So as we last saw it, that is how it left, and effectively that was an allowance for open banking, which we all kind of agreed was already probably allowed, but what was lacking was any sort of regulatory structure around how that open banking would look. And so the rest of that legislation was directive to the Division of Banking to work on a regulatory structure that provided some consumer protections, best practices, and how that open banking would operate. So it effectively holds the open for business sign up, and then puts and builds that regulatory structure that we talked about last time around it, so that once again, hopefully we'll be a leader in that space, and others can be looking to Wyoming for how to engage in open banking practices if we are successful.
We have any other minerals members? Just the two of you. Okay. All right. Sounds like that's in good shape, and looking forward to seeing it in the session. And Representative Western floor managing it on the House side.
Yes.
Okay, public comment? Bankers, Scott?
Morning, committee. Scott Meyer on behalf of the Wyoming Bankers Association. I think Senator Rothfuss did a great summary of what happened up at Minerals. One of the things that was brought up, and I had to kind of smile at myself just because of the way that the timing was, but Senator Rothfuss said, we've got to do something. Nobody in the feds has done anything for 12 years. By the time I got home, there was a notice out that the CFPB is now taking this on. So for whatever it's worth, that thing that came out from the CFPB was, their directive came out on October 27th of 22, and it outlined proposals under consideration.
Scott, what is that? Sorry, what is that? Consumer Financial, what is it?
Consumer Financial Protection Bureau.
Okay.
And they outline proposals under consideration that would require businesses to make a consumer financial information available to them or to third parties at the consumer's direction. The rules would implement Section 1033 of the Dodd-Frank Act, which also directs the agencies to promote and develop the standardized formats for information that's available to customers. The CFPB is considering proposals that would allow consumers who want to switch providers to transfer their account history to a new company so that they do not have to start all over with if they're unsatisfied with where they're getting their information. That's going to probably be an issue just because each institution will probably have their own requirements. But the Bureau is also considering proposals that would include options around privacy, which is our big concern, for personal financial data authorized for third-party use, including limitations that would prevent third parties from reselling authorized data to other users. And comments on those proposals are actually due by January 25th of 23. I will tell you the CFPB is required to convene a small business review panel to consult with representatives of small businesses likely to be affected by the regulations of the agency and those actions that they're considering. The panel will prepare a report on the input from the small entities, which the CFPB will consider as it develops all its proposed rules. All I can tell you at this point in time is that the WBA and our members are fully supportive of consumers' ability to access and share their financial data in a secure and transparent manner that gives them control, the consumers. Today, banks, data aggregators, and other technology companies are collaborating to build tools, I think, that move away from less secure methods like screen sharing and to these more secure APIs that we've talked about. And I think that protects and empowers consumers. As we have stated prior hearings, I think our biggest concern is access to consumers' data that we believe must be held to the same high standards and supervision related to data security that banks are required to do. So we look forward to working with this committee. We look forward to working with our Wyoming Division of Banking, and we look forward to actually working with the CFPB because we will be sending comments.
Mr. Chairman?
Mr. Co-Chairman, please.
And I'll note, I appreciate that update. One thing that we discussed briefly was that obviously the CFPB product is something that then our Division of Banking can draw upon when drafting rules and regulations if we end up passing the legislation, and that's pretty handy. So they've been working on it for the past 12 years and haven't actually finalized anything, but it's a nice feature that they have a lot of the framework effectively built, and it's just that nobody's pulled the trigger on it. And then from a workload standpoint and talking with the Division of Banking, we could, if we choose to, set some high-level policies, like, for example, express written consent was what we included, as opposed to just a click box opt-in, something like that was one of the provisions that we did include as a minimum requirement. We can work to set those robust requirements and then utilize the work product so far of the Consumer Financial Protection Bureau. And once again, hopefully lead in this space. And Mr. Meyer, I don't know if you have any new information from last time, but one of the things that we talked a little bit about at the Minerals Committee was what is the likely timeline of them taking formal action? Do you have any more information on what a likely timeline would be for that?
Yes, Mr. Chairman, I will tell you that I think that with rules, comments being issued into January, we'll see something in 2023 as far as drafts come out. And I think that will push it. I think the goal right now is to have it in 2024. And as we kind of discussed in minerals, I think our biggest concern is, and it's really none of my problem, it's just we observe it, but dictating that the Division of Banking come up with rules that all of a sudden now they have to change because, our banks, a lot of the institutions are FDIC, so we have to follow federal rules. I mean, it's just requirement. So it'd be a shame for them to come out and do something it also ultimately gets changed, but I can't imagine that they wouldn't be too much on the same page. I think they pretty much are. But
Representative Western?
And Mr. Chairman, Mr. Brown, I think that's a valid point. I think any kind of inconsistencies or incongruities, I would certainly like to think that this committee would be more than willing to take that up in the 67th to address that and make them congruous. Is that a word?
It is.
It is, excellent.
Congruent.
Thank you.
Okay, yeah, I was just reading online about this timeline. It looks like in the first quarter of 2023, so they're trying to get and the proposed rule is expected, and then finalization and implementation by 2024. So might not be the 67th, but maybe it'll be the 68th.
Well, just listening to Senator Rothfuss in minerals and his talk about the 12 years, and I thought, this is kind of like the Kansas City Chiefs. There's only a minute left. There's no way they can come back. Now they came back, so they're here.
Unfortunately.
Yeah.
That just spurred a lot of PTSD
That's
for me.
right.
Right.
That's painful.
Well, all right. Any other questions for Mr. Meyer? All right, we do appreciate it. Thank you.
Scott, good to see you.
Thank you.
How about our Division of Banking? Any comments? You don't have to
We've
comment.
got them next, actually, your general updates also.
You've got general updates.
We can see if anyone else wants to talk.
Any other public comment on open banking? Public comment going once, going twice. Online? Closed. All right, Division of Banking. Welcome, Commissioner.
Good morning, thank you. Just for the record, Jeremiah Bishop, Commissioner for the Division of Banking. Thank you for having me up again this morning. I don't have any specific updates on open banking today. I think we've discussed this at length at prior meetings. We were testified at the Minerals Committee, and moving forward, we'll make similar updates on that bill moving forward. One of the things I did want to update you on was at our last meeting, the question was brought up of kind of going through an analysis of what are the division's options if we were to see a surge in SPDI applications. The committee asked me to come back, okay, what steps could we take to make sure that we could process those in a timely manner? At that time, I mentioned that with our current resources, we could realistically review one official application at a time, and that's what spurred this analysis. And so I just want to give an update on that. So I kind of want to go through what our current process is for reviewing applications, and then going through possible things that we could do to basically process more than we are now. So currently, our process is we meet with a company who's interested in this space. We set up a meeting with the people involved in the company, maybe their general counsel. We go over their rough, high level, what their business plan is, products and services, and most of the time that's when we give them feedback of just what the SPDI is and does it fit for their purposes. From there, if they want to move forward, we ask them to give us a draft written business plan. We go through that. We have a kind of a standard list of questions, but it depends on what products they're getting into. We provide questions and feedback, and then we kind of go back and forth a number of times. This could take several months. It just depends on the company and just the quality of that business plan. This is when we really flesh out how complex is this institution, and kind of where are they in the process? Is this more than they need? Is it maybe a trust company charter might fit better? But it also allows us to really kind of get a good timeline of when are they ready to apply. Once they officially file an application, we now have a statutory deadline to move through that application. So we want to make sure that we're all comfortable with it by that point. We found that if a company were to just give us an official application without us looking at it, there might be some questions that would put them in maybe in a tight spot in front of the banking board. So we found this draft review process is very helpful. One thing this also does is it allows us to look at more than one application. Obviously, we might have multiple draft business plans at one time. We can kind of prioritize which one's ready to go faster and get through that bottleneck of one application at a time. We found that actually works fairly well for us, and I think our companies, the feedback we've gotten is they appreciate that process. So what I want to do is just kind of walk through the possibilities. This is, I think, the scenario is we get a lot of applications all at once. I think the direct question last time was if it looks like our SPDIs might be getting a master account at the Federal Reserve and we get 100 applications, what do we do? So a couple things we can do. One is we can add positions. This would need to be, affect our permanent budget, and so that'd have to run through the appropriate channels. I think as far as a timeline on this process, it really varies just depending on where we are in the budget cycle, where we are in the legislative cycle, just because it would have to go through that avenue. So another option would be for the legislature to actually pass a bill that gives us these positions. This option, one thing it doesn't do is it doesn't guarantee that we can actually fill these positions with qualified people that can actually process these applications coming in. Currently, we've had struggles finding people in this space that can actually come in and do this. We have empty positions currently. So our process in the past has been to bring people in at an entry-level examiner position and then train them in this area to fill those senior-level positions. So that's one of the struggles if we were to go down this avenue of adding permanent positions, but it is a possibility, but the big unknown is just the timeline. It could be fairly quickly, like right now, we could probably get that through the next session if we needed it, but it could also take till the next year.
Mr. Co-Chairman.
Thank you, Mr. Chairman. Commissioner, on that point, one of the concerns that has been expressed in the past that we've worked with is the fact that the salary schedule for some of these positions is inconsistent with the market, and that makes it challenging to bring in people at the appropriate skill and experience level to do the work. Is that still the case? Do we have any solutions on the horizon to remedy that? Can you comment on how we're going to handle and resolve?
Commissioner Bishop.
Yes, thank you, Mr. Chairman. Yes, it is still the case. However, we've made some requests in the last month to hopefully help remedy this. It may not get us fully where we'd like to be, but it will definitely help. We currently have a B11 submitted, and I think we'll be making a supplemental request at the next session to help with this.
And it's my understanding that the revenue is available based on the structure of the Division of Banking, where it's a fee service model. So the appropriation side from the financial standpoint is not the concern. It is the authorization for the positions, as well as the classification of those positions so that they can be paid sufficiently to meet the market. Is that an accurate assessment?
Yes, thank you, Mr. Chairman, Co-Chairman. Yes, I think that's an accurate assessment. We are another funded agency. We do bring in fee revenue to pay for our costs. I'd say currently the attitude with our institutions is they are willing to pay higher fees if it means better employee retention on our side. They've been doing a very good job of making that known. It does still have to go through the appropriations process, even though it is other revenue. I won't make any comments on their attitude towards other revenue, other fund agencies. I believe it's a little bit easier process, but that's not a guarantee.
Thank you.
Representative Stiff.
Mr. Chairman, Mr. Bishop, do we expect a lot of applications for special depository institutions?
Commissioner Bishop.
Yes, thank you, Mr. Chairman, Mr. Stith. Yes, I think the assumption is right now the existing 4 SPDIs, none of them currently have a master account. I think the worry is that if one of them is granted a master account, I think that'd be great for their business. However, I think that would bring in a lot more interest from the industry in an SPDI charter. And I think if that were to happen, I think we would expect an increase in potential applications.
Mr. Co-Chairman.
And just following up on that anecdotally, there are companies very interested in the SPDI Bank charter, but without the master account availability, they haven't pursued them. And so they're waiting on the outcome of that circumstance. So it would be reasonable for a surge, who knows how big that surge actually is, to occur if the master account circumstance is resolved.
Yes, I think that's an accurate statement. So kind of moving on, or another option that we could do if we were to see a surge, and that would be to contract with a third party to basically process these applications for us. And for that process, we'd have to go through the very well-established RFP process. The estimated time frame for this approval it varies. We can't give you an exact deadline or a timeline on this, but we'd probably expect roughly 6 months to get through that approval process. There's a lot of steps along the way. It would have to go through the procurement office, budget office, the governor's office, the AG's office, and in our case, most likely ETS, just because there would probably be some type of software computer aspect to that with our current system. So once that approval process goes through, we could select the institution that we would like to partner with to handle these applications, and then they could actually begin helping with this. So I just wanted to wrap things up. Just if this were to happen, what would we do given these options? I think if, for example, we'll know if a current SPDI gets a master account. And at that point, we'll be receiving a lot of interest from the industry. We'll be having a lot of scheduled meetings. So it won't be a day one applications on our desk. Hopefully not anyways. And so we would be able to see it coming. We'd be having a lot more of those initial meetings. We'd be looking at a lot more of those draft business plans. And so that would actually give us a few months to start this other process. And so once we saw that coming, we would immediately try to at least fill any vacant positions we currently have, just hoping we could get somebody in place that is qualified. However, given that that's not a given, we would then start that RFP process at that time, and while still moving as many of those applications forward as we could. And I think we would definitely utilize that draft review process. That would really help us. I will say when the SPDI legislation first passed in 2019, it was effective October 1st. We expected a lot of applications October 1st. It actually took several months. And we were able to spread those out at that time. However, with that, we met with hundreds of companies who were interested in that at that time. 4 of them ended up applying. And so having that initial meeting and that draft review process really does help kind of slow things down a little bit. We don't want to do that on purpose. However, we want to make sure that it's right for those companies, and also that they are very aware that what are they getting into. It's a regulated bank, and there's a lot that goes into that. And so that draft review process would buy us a little bit of time and make sure that we have quality companies coming through. That's all the comments I had, but if there's any other questions from the committee.
All good news, not the perfect news yet, but we're still hopeful. Maybe you will get some more applications. Oh, Joel, go ahead.
Thank you, Mr. Chairman. Just a question for the commissioner, and that is, with the outsourced temporary solution, are the man hours required for approval greater than for ongoing oversight? In other words, would you not need the resources to regulate the approved speedies down the road anyway? I'm just wondering if that doesn't really create a long-term solution for you.
Commissioner Bishop.
Yes, thank you, Mr. Chairman. Thank you, Mr. Everly. Yeah, it's a good question. I think our going through that RFP process with that third-party contractor would be the immediate solution to that problem. However, we would probably, if we see a large number going through and it's likely that those companies would possibly receive a charter, we would also go through the other channel of adding positions if we needed it, depending on what are the resources needed to actually supervise those companies once they do receive a charter. And that's one of those things that I think we'd have to wait at that point to see how many of these are coming, and then just go through that channel of adding positions if needed. But yes, that third party would be the immediate solution.
Representative Western?
Thank you, Mr. Chairman. Going off of Mr. Reville's question, Commissioner Bishop, maybe if you could outline roughly what that timeline would be in terms of both, and because I mean, this isn't unskilled labor we're looking for. These are folks obviously have to have a pretty deep knowledge of this process. Let's say if this master account situation does get resolved and all of a sudden there is the flood that we've kind of been discussing, what would that process look like from you from the time we really see what's happening to the time you've got the staff in place that can really start processing these applications?
Commissioner Bishop?
Yes, thank you, Mr. Chairman. Thank you, Mr. Western. Yes, it's not an exact timeline. I think if we saw an immediate surge in meetings, a lot of draft business plans at that point, we would begin this process. Like I said, I think it would take from that point, this is a rough approximation, 6 months to get through the RFP process. And so we would be handling it with the resources we currently have. And then at that point, we'd also be, at that same time, day one, we'd also possibly, if needed, go through the process of adding positions. And that's the one, it could be 6 months, it could be 12 months, depending on where we are in the legislative cycle and our budget cycle. And so I think with that RFP process being the immediate concern, it would take approximately 6 months from the time that we started that process to the time it got through all the required approvals. And so our current resources would be within those 6 months bearing the load of that and trying to get them to with what we could.
Additional questions for the Commissioner? Co-Chairman Rothfuss?
I've actually got a question for Representative Stith, and I know Appropriations has talked a little bit about A&I and their categorization for position descriptions and classifications. Not just for Division of Banking, but I think for Oil and Gas Conservation Commission and some other areas. Is there any movement or anything going on right now with appropriations that might lead to new classifications, new flexibility, something that addresses these concerns?
Representative Stith?
Mr. Chairman, if I understand the question, it relates to whether you need to have different classifications so that particularly highly skilled employees, that you can attract them into the market. And the short answer is yes, that's been a topic of discussion, but so far, to my knowledge, no action's been taken.
Any other questions for Commissioner Bishop or Representative Stith? No? All right.
Thank you.
Thank you, Commissioner. Actually, I'll take any public comment on the Commissioner's comments. Mr. Meyer, welcome back.
Thank you, Mr. Chairman. Scott Meyer on behalf of the Wyoming Bankers Association. I just want to make an editorial that I'll throw out there based upon what the Commissioner just made a comment on. Just in general terms, we not only expect, but we're demanding of the Division of Banking some excellence in their examiners. It makes banking what it is. It makes Wyoming what it is. And so we've had those discussions. We fully support everything that the Commissioner just mentioned. And, I'm not sure about the raising the fees, but the reality is that what they hold in their accounts is our money. And we want to be able to spend it. We need to have the examiners that make us look good. And without getting too far into the weeds, we all heard a little bit about FTX and Mr. SBF, and I've heard comments from Senator Lummis and even comments from your committee member, Caitlin Long, about that stuff. But the reality is, it comes down to is that we're only as good as the regulators we have. And if we want to look like we're the top dogs, which I think we are, but it puts a lot of pressure on these folks. And so I would encourage any support to make sure that we make those classification changes, we make those salary adjustments, because it really is imperative on our industry to have really good examiners.
Co-Chairman Rothfuss.
And we did, out of this committee, pass a bill a number of years ago, about 3 years ago, I think, to address that. And the bill passed the legislature. The governor vetoed it and said that he'd effectively address it and take care of it, which is the source of the concern that I have. Is here we are a couple of years later, and I don't feel that we're fully staffed, from what I understand. And I think the reason that we're not fully staffed is because we are not paying fair market wage. So, we look forward to continuing to work with you to try and address that, because absolutely, it's not just about speedy banks. It's about the integrity of the entire financial system in the state of Wyoming. We have to have high quality regulators with experience. We have to have enough of them. We have to do good work, because we do tout the fact that these circumstances that we've seen recently wouldn't occur had they been regulated in Wyoming. And I think that's true. But if we don't have the regulators to do the work, then something might sneak by. So thank you for that.
One other comment, Mr. Chairman and Co-Chairman Rothfuss, is that, we talk about in this committee and in other committees, economic development, and the legislature did pass a bill that allowed people to move their charters. Now, I fully expect to try to push on that to see what we can do to make people want to move their charters to Wyoming. We have a great tax structure. We have, great laws that support the financial industry, but this is a key part. So.
We should bring that bill back.
Yeah.
Let's do it.
What was that? It was a one paragraph bill.
It wasn't long, that is true, because it needs.
David could find that bill pretty quickly. Ms. Long?
Mr. Chairman, just to follow on the comments that we just heard from the Wyoming Bankers Association, if we go back to the history of the Special Purpose Depository Institution Charter, the deal that was cut back in 2019, I believe, was that the Special Purpose Depository Institutions would pay 2 basis points on assets in Wyoming, which would by definition be all of them because these are Wyoming corporations, that 2 basis points would be paid into the Division of Banking. And the fact that none of the chartered SPDIs are yet operating means the feds have blocked that. And so that revenue is not coming into the Division of Banking, which would have helped to alleviate the situation. One thing that all the state banking commissioners are facing is that when someone gets trained in digital assets, as we've seen here also in Wyoming, that the lure of the private sector tends to be very great. We've experienced that here, and my company has experienced that as well with our federal potential regulators. And as a result, it's tough for the regulators to retain qualified people, especially once they get trained in digital assets and jump to private sector. So I would just remind you that there are fees coming in. The traditional banks do not pay those fees. They are exempt. That's the industry. That's been in the case for a long time. They don't even pay the 2 basis points to the Secretary of State's office. The traditional banks don't. The special purpose depository institutions do pay the 2 basis points, but do pay it into the Division of Banking. There is not a tip over provision like in the Division of Banking like there is with the Secretary of State. But the funding alleviation could actually happen in theory fairly quickly if operating businesses, unlike Custodia Bank, which is not yet operating, well, we have our charters activated, but we're not yet generating revenue, we're not operating. But Kraken Bank, of course, would be, right, because they're an operating business, right? So there are scenarios in which the revenues come in fairly quickly. But I just wanted to flag that because let's remember why we did this in the first place. There was ultimately a desire to get more funding into the Division of Banking. It's been blocked by the feds. And so, but there's also the prospect, I know appropriations, to Representative Stiff's earlier comments, have looked at when and if those revenues do come in, is there a tip over provision? There's a lot that could be done here to sort of break the logjam, but some of it might happen when and if the logjam is broken by the feds too. Thank you.
Senator Murphy, please.
You need a motion to bring back that bill. I would like to see that happen. I think we need to bump those fees of our examiners at the state level. And if you need a motion, I would make a motion to bring that bill back for consideration at this committee.
Did the bill address fees or was it just pay?
Just pay.
Just pay. Are you still interested in that bill? It's just pay. It's what they can pay. Do they
No,
fall
I'm
outside of
interested in the pay increasing, because as was just pointed out,
I see.
there's going to be competition for our examiners, and we need to be competitive. So I'd like to try it again, even though it got defeated once, but I'd like to try it again.
Okay.
And I'd make a motion to that.
All right, we have a motion on that bill. What was have you found the bill?
It's Senate File 140, 2020.
I can email the link really quick too.
Let's take a look at it. Did you, David, did you draft this bill or was this prior to you?
This was prior to my,
Oh, okay.
I barely started.
Would you feel, have you looked at it? Would you feel comfortable introducing it?
It's not very long. I could walk us through it.
Okay, will you walk us through it?
Sure.
There was a second on that motion? Yep, by Representative Western.
It was 2020, Senate File 140, if anybody's, let me just say it on record. Mr. Chairman, it was 2020, Senate File 140, Banking Division Classification and Salary Exemptions. If anybody's trying to pull it up.
Okay, let's take a look at it. Here's
Just-
David,
I
he
did
just
email a
emailed it.
link. If
Great, thanks.
that should take you to that. Would you like me to walk through it now?
Yes, please. This was Senator Rothfuss's bill.
A little bit.
I thought it was a committee bill for some reason, but it is the committee, was the committee.
Yeah.
So walking through Senate
ahead.
File 140. Oh,
Sorry, go ahead.
thank you, Mr. Chairman. David Hopkinson walking through Senate File 140. What this bill draft did, and again, this was 2020 Senate File 140 for anybody listening. It amended Section 13-1605 by creating a new paragraph dealing with obligations or what the banking board can do. And it provides that the banking board shall, except for the salary of the commissioner, as otherwise provided by statute, it shall establish personnel classifications and salaries for the division of banking subject to legislative appropriation. Those salaries were to be commensurate with other state and federal financial regulators and the specialized skills required to supervise speedy banks and financial technology. The classification and salaries were not subject or shall not be subject to the classifications or compensation plan established pursuant to the other, or the, I guess, I believe those statutory references are to A and I, and that those provisions would not apply to personnel of the Division of Banking.
So we would definitely need to change our effective date.
And then, Mr. Chairman, and I apologize, I'm just realizing I was looking at the introduced version, but there was some amendments on the.
Okay, let's look at the enrolled version.
And so just looking at the wrong version, my
That's
apologies,
all right.
Chairman.
We're shooting from the hip right now.
So the enrolled version did include requirements for reporting to the Joint Appropriations Committee and reporting to them what those classifications and salaries would be, and that they include those in the department's exception budget. And then Section 2 provided that no increase in any person's salary or revision to the personnel classifications require an increase in the expenditure funds shall be effective until approved by the governor. And I think that was all that was different. If you'd like
Mr. Chairman, I could just briefly go over the veto message if the committee would like to hear that as well.
Let's do that. Yep, let's do that.
So the governor did veto that message, or did veto this bill on March 26th, of 2020. Primarily, he expressed concerns relating to the separation of powers, expressed concerns to the duties of the Joint Appropriations Committee were a little unclear, expressed concerns that the banking division employees being members of the executive branch, his preference was that those remain with the Department of A&I. And he didn't like the procedures that were established in the Senate file for, he felt, or writes that those were cumbersome procedures for the Division of Banking to make those recommendations to the board. And I think those kind of highlight the concerns that he had, but of course that letter is also available from that link that was emailed out. With that, Mr. Chairman, I'd do my best to answer any questions, but it's good.
No, that was good. Straight from the hip. Good job.
Mr. Chairman, now let's find like a 30-page bill and see if you can do it.
Yeah. Pick another one, Senator Furphy. Senator Furphy, as I'm looking at this bill, this is a good bill. We definitely want to advance this bill in the session. However, this committee cannot advance this bill because it is a Title 13 bill. It will have to go through Minerals, and Minerals has already had its final meeting. So unfortunately, our committee won't be able to sponsor it because it won't have had time to go through Minerals. But I think we should bring this as an individual bill. Okay.
Mr. Chairman, quick follow-up.
Yeah.
I think it's a great bill to have a bunch of members of this committee co-sponsoring for the upcoming session, and to get it redrafted and maybe work on some of the fine details that raised concern for the veto letter. There is some lack of clarity, certainly, and that was through amendment over in the House as opposed to the original draft, so we can probably clean that up.
I feel like I remember that amendment. Okay. All right. Thanks for walking us through that, David. Hopefully we will see that bill during the session, just not through this committee. Anything else under special depository institutions before we move to the next general update? Oh, you're back. You're
I'm
still there.
here.
Never left.
Mr. Meyer.
I don't know if there's any other questions. I will just throw out an editorial that without making any disparaging, and no intention of making any disparaging remarks about former Commissioner Faulkner or my predecessor, but I will tell you that from the WBA standpoint, the relationship between the WBA and the Division of Banking has never been stronger. We support that kind of an effort that Senator Furphy had brought up. We will do everything we can. We understand that Commissioner Bishop he's got certain restraints on what he can and can't do. We have had that conversation with Governor Gordon. He understands the importance, and I think he will be very willing to work with us at this point because he understands where we're coming from and why we need this. So,
Excellent.
Mr. Chairman?
Mr. Co-Chairman.
I know one of the other concerns was just sort of the idea of, well, if we provide this opportunity for the Division of Banking, then everyone's going to ask for the ability to set their own salaries. That is something for us to think through. The challenge that I have with that argument is if we do things right for one agency, why should we, then we'll have to do things right for the rest of the agencies. Isn't as compelling when phrased that way. So, I'd love to see this first step, but it is something for us to give some thought to because we have had discussion on the Minerals Committee, for example. Oil and Gas Conservation Commission can't hire engineers because the engineer classification is about half of the value of a typical engineer that they would hire into that position. Turns out that's a challenge in the marketplace to get someone to accept half their pay there too. So it's a much larger problem, but certainly our responsibility is to address these particular concerns and within our scope. As we contemplate it, though, potentially for a individual bill that hopefully many of us will sponsor during this session, maybe there is a broader solution. So if everyone wants to try and think that through, then
Yeah,
I just
Mr.
encourage
Co-Chairman,
everyone to do so.
I'm kind of on the same page as you. I'm interested to have the broader discussion because, we also have this issue with our treasurer's office and our investors.
Yeah.
And our advisors. So just in my short time here in the legislature, it seems to be surfacing more and more. I'm definitely interested in a broader conversation as well.
Mr. Chairman,
Yes.
just for kind of our clarification and purposes of the minutes, there was a formal motion made that was seconded.
And
What's the disposition?
Sorry,
He did withdraw it. I must have missed that. That's
Yeah, for
fine.
the record, the motion was withdrawn
Perfect. Thank you.
or stricken as inappropriate by the chairman.
Ruled out of order. You want that in the minutes?
Yeah, I want the minutes to
Okay.
say that I ruled Senator Furphy out of order.
It sounds cooler. Good choice.
All right. Anything else? Oh, Mr. Meyer, you're still there. Anything else on?
Members of the committee, not unless you have any other
Why
questions.
don't you just
on-
stay there for the rest of the meeting?
Right.
Committee, do you have any questions for Mr. Meyer? All right.
Thank you.
Thank you, as always. Any other public comment on special depository institutions or any updates from the banking commissioner? Anything online, Emily? No? Okay, we're still waking up, I think. It's Friday, too. New image likeness discussion?
Name image like.
Name, image, likeness, I'm still waking up discussion. Representative Yin.
Mr. Chairman, thank you. So I don't think we actually had, so what had happened at the last meeting was that there was a motion to have a bill draft, which is the next draft on our agenda, plus a committee or a working group discussion in between meetings. I think in the whirlwind of the election season, that didn't quite happen, unfortunately. But I know Mr. Mayor had comment that he had emailed to us, so I think that there is some willing discussion about it, but I don't have anything to report from in between our meetings.
Okay, we also have Professor Fry, is it? And Mr. Reville, do you have anything to add ahead of the good professor?
Thank you, Mr. Chairman. I'll just set the table for the conversation, and with Professor Fry able to join it is great. Just as a reminder from a brief conversation at our last meeting, the concept here is that historically, if you had content, you would monetize that content by selling copies of it to consumers. And with the evolution of the NFT market, that enables content owners to monetize the value of their content, not by selling copies, but rather selling an interest in their brand or in their celebrity or in their project. And so the theory here is that the value of content in the NFT market depends more so on branding as opposed to copyright, which I don't want to take too much of Professor Fry's thunder here, but does allow perhaps an opportunity for state law, trademark law, that would potentially align with the needs of the NFT market and align with our existing digital asset laws. So that was my comments. Would love to hear Professor Fry's comments as well, if you agree, Chairman. Thank you.
I so agree. Professor Fry, welcome.
Hey,
Thank you for joining us on such short notice.
My pleasure. I'm delighted to be here, and it's a pleasure to talk to all of you. And it's really great to see the Wyoming legislature being so forward-thinking in this area. And thanks especially to Mr. Reville for inviting me. We had a nice conversation a while back where we kind of discussed some legislative possibilities that Wyoming might look at in the kind of blockchain NFT space in relation to state intellectual property law that might be both innovative and productive in that context. And in the course of our discussion, I pointed to both state trademark law and state rights of publicity law or name, image, likeness laws as ways where Wyoming might do some innovating. The reality is the state trademark law is not as powerful in a lot of ways as federal trademark law. Although I do think there's room for innovation in that area, and it might very well be looking at. I think the area where there's the most potential for meaningful impact would be in state right of publicity laws, in part because Wyoming doesn't currently have a statutory right of publicity law, unlike many other states, although not all states have them. But that does seem like, to me, it seems like an interesting opportunity to think about what a law like that might look like and how it might explicitly recognize the kinds of interests that people with celebrity value to their personalities might have in the NFT space. And as Mr. Reville mentioned, my belief is that much of the value of the NFT space is tied up with in branding, and also more specifically in celebrity, the kinds of associations that people have with things that they like and that they feel very positively about. A great example of that recently was Quentin Tarantino, for example, selling millions of dollars of NFTs relating to his work on the film Pulp Fiction. I think other celebrities are already starting to see NFTs as being a way of monetizing their celebrity value, and thinking about how to draft a law that would recognize that in a kind of a broader way, I think would be a real innovation in the right of publicity, name, image, likeness space, and perhaps be very appealing to people who might be thinking about how to pursue their interests in that space.
Committee, any questions for Professor Fry? Let's bring Brendan in as well. I'm sure he has some comments to make. Okay, great. We're going to try to build upon this conversation with Brendan Mayer. Welcome, Brendan.
Welcome, committee. I suppose I should do a minor statement of who I am. So I'm Brendan Moore. I'll keep it short. I'm on the working group for digital identity and other things. I would like to say at this juncture that I completely agree. And I do believe that also having worked on the registered digital asset legislation that we'll be talking about later on in the day, that what is going to be needed is a few different kinds of bills. So we actually have the Registered Digital Asset Act specifically for IP, but as I'll discuss later, it has come to our understanding that things of the nature that we're talking about here, which is really related to identity, right? Personas, influencers, all of this stuff. Identity is going to require separate legislation, merely for the fact that we can't burden the Court of Chancery with billions of dispute cases regarding low value registered digital assets that are not worth challenging in the Court of Chancery. And also the cost is too much. You need $300, you can't have everybody's digital identity where they're paying $300 for each DID. So it is going to take some thinking this through as a separate piece of legislation. That's what I have to say right now. Thank you for your time.
Okay. Committee, any thoughts or questions? Representative Yin?
Mr. Chairman, I think it's unfortunate that Senator Nethercott is not here to also weigh in on this.
Yeah.
But while we have that draft bill in front of us, we could decide to amend it, but I don't have any potential amendments at this moment for that bill.
We have a draft bill? I don't think we have a draft bill.
We have 23 LSO 0171 that is next in our agenda, which was related to
Oh, you're talking about for the.
the digital asset registration,
Registration, okay.
but having something similar for digital identity. But like I said, I don't think we have anything concrete enough at this time, so maybe it's something that we move forward with next year.
Yeah, something that we make more purposeful on our interim list for next year. Mr. Reveal, any other comments or thoughts?
I have none, thank you.
Okay.
Mr. Chairman, I
Yes.
believe Professor Fry has his hand up. The yellow is just blending in with his.
It is blending in with the yellow. Professor Fry, please.
My apologies. I wanted to say I agree with Mr. Mayor that legislation would at least be worth discussing. And if there is an interest in assistance, I do teach classes in this area and also produce scholarship in the area. And I'd be delighted to be of assistance in any way that I can be.
Professor, we will not hesitate to draft you. We need all the help we can get if we're going to make this space meaningful next interim. Representative Yin?
And Mr. Chairman, thank you. Mr. Fry, there's still time between now and the session. It just won't be through a committee, but any one of us on the committee that are legislators could sponsor a bill if there is language that makes sense for us to do before January. Thank you.
Yep, that's right. Brendan?
May I make an additional comment? I was going to save this for later, but it might fit better here.
Nope, go ahead.
Yeah, so ideally, what I would like to see is, instead of having a blue check mark for digital identity, Representative Olson, I know that you've put forth in the past the buck and rider as a symbol or something that should be registered as a digital identifier, registered digital identifier, and that's kind of what the same thing we need here. And not, just to be clear, not that the buck and rider would be the symbol that people would be able to submit their own DIDs, their own NFTs, their own whatever for these purposes, but it's kind of a metaphor. But the napkin math is what's important here, and the napkin math is, if you had people willing to spend $8 a month for their blue check mark for digital identity, and you have 300 million people across the country and $8 a month, that's $2.8 billion. So somewhere between zero, which is what you're getting right now, and $2.8 billion is probably something that the Secretary of State might find interesting. This is not just related to digital identity. Really what this is about, and we keep coming back to all these things because we keep circling, because this is all the same conversation. This is really in part what the whole constructs of the legislation around e-residency that Christopher Allen and I and others have been speaking about for many, many years. And it is going to be the case that when we solve this next step regarding legislation around digital identity for registered digital assets, that there is going to be some kind of legislative relationship to the construct of e-residency, and we're going to have to come back to that as well. So I think that's all I have to say at the moment, but I hope that helps frame the thinking about all of these potential motions for legislation. Thank you very much, and I'll take questions.
Any questions for Brendan? Committee? Nope. Okay, I do think this is on our, if we can at least just make a note to, so we don't forget about this when we come back around to setting interim topics, LSO. If you've got, start compiling that list, that's helpful for now. Okay, thanks everyone. Any public comment on name, image, likeness discussion? Any other public comment in the digital world? Emily, anyone else? Okay. Let's move to truck coin swap. Come on up, gentlemen. Go ahead and introduce yourselves, and then the floor is yours.
Excellent. Just want to thank the committee for the opportunity to be here today. My name is Todd Ziegler. I'm the CEO, and I'm joined by Jake and Phil. I'll let them introduce themselves.
Hi there, I'm Philip Schlump, and I'm the Chief Commercial Officer for Truck Coin Swap.
And I'm Jacob Zentner. I'm the Chief Technology Officer for Truck Coin Swap.
If the committee would allow it, I just kind of wanted to make a few comments on what's going on in the macro. I'd like to talk to you a little bit about what we're doing, and then Jake and Phil have a couple comments on the ask that we'd like to put before the committee today. On Wednesday, I was in Washington, D.C. with former Speaker of the House, Paul Ryan, and a couple members of Congress. Representative Ryan noted that we're at a crossroads right now in Web3. I think most people would agree with that. And he likened it to the era in the 90s when Congress was drafting legislation to determine whether the internet would be a decidedly American endeavor or if we would allow all that innovation and opportunity and revenue to offshore. And he noted that, you know, he was very grateful to be part of the solution in getting that right. He also advised that a number of folks on the Hill are advocating Congress right now to strike up a regulatory framework that allows Web3 to advance as the internet did. And I would say that there is a great deal of optimism on the Hill for that to happen. Many people have been noting that the fall of FTX will probably expedite Washington's delivery of a regulatory framework. And ideally, we see a good deal of jurisdiction vested in the CFTC, and hopefully that utilizes the bill championed by Senator Lummis. Firms like BlackRock, Fidelity, and Citadel have already dipped their toes in this asset class. And we think that Washington's regulatory framework can help create the green light that these institutions need. As many of you know, if something like 1% to 2% of assets under management from these firms moved to Bitcoin or similar digital assets, we would most likely see Bitcoin surpass 6 figures in value. At least that's in accordance with what's been noted by many finance experts. None of this should be a surprise to the committee. This is a legislative committee that's helped lead to the creation of one of the most innovative regulatory frameworks in the world for blockchain and Web3. And that is the reason that Truck Coin Swap is incorporated in Wyoming. And that's the reason that we are creating Made in Wyoming solutions in a $2 trillion domestic supply chain industry that is now converging with blockchain right here, right now. So what is the problem that Truck Coin Swap solves? TCS has created a blockchain solution for free and fast freight receivable settlement utilizing a digital asset and a mobile app. Why does this solution matter to small businesses, households, and consumers? The problem that we're addressing is that the cost of goods are not just going up due to inflation. Costs are also increased tremendously in the supply chain every day due to settlement fees and costs, because industry standard pay terms for almost every shipper are 30 to 180 days. This problem causes transportation companies to have to borrow cash from banks and third-party intermediaries against their accounts receivable in order to fill up the truck, pay their operating expenses, and get to their next load. By industry averages, the interest rate they're paying is 25% annualized, and the true cost to carriers can escalate up to 90% of net revenue on every single truckload of freight. So who pays these additional freight costs? The trucking companies, the shippers, or the grocery stores? You guessed it, just like inflation rolls downhill, all of these wasteful financing costs are passed on to consumers in the form of higher prices. So how does all this translate in real time? And in order to kind of make the point, I want to run through a couple supply chain statistics that impact or are impacting all of our families and friends and colleagues next week. 85% of Americans cannot afford to spend $200 on Thanksgiving next week. 73% is the average year-over-year increase in the cost of a turkey. 45% of Americans are stressed about the cost of Thanksgiving, and 15% of Americans will eat pizza next week in lieu of traditional fare. Rather than try to fix this problem from above, for decades, Washington has allowed banks and factoring companies to prey on consumers and households, and rampant inflation, which I think we would all agree is a monetary tax, has now exposed the factoring practice even more, which is really now akin to another layer of silent taxes on everything that we buy. By industry averages, more than 1 million American trucking companies are factoring every single receivable that they generate, and more than 50% of third-party logistics companies are doing the same. So to break that down on a more granular level, for a single truck owner-operator hauling 150 loads a year, these factoring costs can exceed $30,000 a year in net revenue. When trucking companies lose that much revenue, it costs them substantially more to operate, which of course forces them to charge higher freight rates. But what about medium and large trucking companies who have a settlement department and don't need to factor their invoices? Shouldn't these egregious costs compel companies to grow and avoid factoring fees? The answer is yes, but their problem is now inflation. So I want to give you a simple example. You own 100 trucks and have an internal settlement department, but a majority of your shipper customers pay on 90-day terms. If inflation is 12% a year, and I think most of us would disagree with Washington's 9% figure, and again, turkey costs are up 73% year over year. But if your pay terms are 90 days, then every month of waiting creates a 1% loss in your invoice value. Over 30 days, you lose 3% in the value of that invoice. But it's worse because you're also payrolling a settlement department. So restated in many instances, a larger trucking company is currently paying more to settle its invoices than what a single truck operator is paying. This example demonstrates that trucking companies and 3PLs have no financial incentive to grow in 2023, and how systemic the financing problems are throughout the entire American supply chain. The blockchain solution created by TCS solves the problem by creating fast and free freight settlement. Instead of advancing cash, TCS settles transportation companies in TCS's Polygon token, minted right down the road in Laramie. At settlement, the current dollar value of TCS token is directly deposited into the trucking company's digital asset wallet, where it can then immediately be sold and converted back to US dollars, avoiding both factoring costs and crypto volatility. TruckCoin like a bank or factoring company, then waits for the shipper to pay and makes money when these payments are received. TruckCoin launched TCS token on 2 major exchanges in September at the University of Wyoming's Blockchain Stampede, and is now working with larger exchanges like Coinbase, Kraken, and Binance to get the token onboarded. Further, 2 weeks ago, TCS launched its mobile and web app to 20,000 attendees at the FreightWaves Future of Freight conference. The demo concluded to thunderous applause, and TCS has been approached by transportation strategics representing access to more than 3 million American trucking companies. Working with these strategics, TCS is now charged with demystifying crypto and blockchain to the industry. However, but for this committee, no part of this innovation would have happened in Wyoming, and I would argue it may not have happened at all. Wyoming's done a tremendous job of building a neighborhood for companies like TCS, and I want to turn that topic over to Phil and Jake for a little more discussion.
So what we'd like to bring to the committee's attention this morning is a very general issue of marketing. 2 weeks ago, our CCO, Philip, went to a blockchain conference in LA, the Los Angeles Blockchain Summit put on by the venture capital firm Draper Goren Holm. He spoke to over 20 blockchain venture capital funds. So Philip has been building businesses and software for over 30 years. He's very familiar with the technology startup space. And every fund he spoke to naturally asked where TruckCoinSwap is based. And when he told them Wyoming, every fund he spoke to was surprised. He had to explain to them that Wyoming has passed dozens of bills to provide a real regulatory framework for blockchain companies, and that's a problem. Wyoming has yet to market itself to the startup world, to technology startup companies and venture companies. The committee has done the hard work of writing the laws, and we've also started creating a community with events like Crypto Mondays, conferences like the Blockchain Stampede, and more to come. But blockchain companies building here won't get far without funding. And the startup world is still unaware of what Wyoming has accomplished. So I want to turn it over to Phil to talk about some potential solutions.
It would be an awesome thing if, there are other states that have gone out and marketed various different things, usually to tourism, and it's very expensive. But this is a different kind of a marketing ask, that we actually go out and market specifically to the people that can influence new startup companies. This is venture funds, this is angel groups, and there is a small target out there to market to say, you know what, we've actually built something really special in this state. This is the work that you've done, and actually go out there and market to them, have an email list that discusses what we're doing to make this more possible and why these people should get their companies to rebase in Wyoming. And your work is not going to get any, this is the blockchain world where half of everything is marketing. And tremendous work will go to waste if you don't get out there and actually build this list and start contacting these people and actually making certain that the world understands why Wyoming is now unique and special and has something to offer in this market that no one else does, which is regulatory frameworks that are different than the rest of the United States, different than the rest of the world. And there is a lot of value to that. And it will make the blockchain space, the NFTs, more valuable to everyone if we do this. So that's really the ask that we have is, I shouldn't be going out there and hearing, well, why would you want to build in Wyoming? And what attracts you to Wyoming? That's not what you should be hearing. You should be hearing, oh yeah, you're in Wyoming. That's a good thing. That's why you should be building and where you should be building.
Representative Western.
Okay, Mr. Chairman. So you're asking us to invest money in marketing.
Yes, that is correct. I'm asking you to invest money in marketing. It's probably not a huge amount of money because it is a small set of entities that you would be marketing to. But an email list where you actually get them to say, yeah, we'd be interested in hearing this, and you call them up, talk to them, and say, here's our new things that we're doing. Here's how it will benefit the companies that you're working with. Here's the stuff that we're providing so that the VCs, the angels, the funding people can talk to the companies that they're working with and say, yeah, we're looking at what you're doing, but you shouldn't be in some state out there. You should be a Wyoming company. You should be taking advantage of the laws in Wyoming that help you build this business. And that brings the money here.
Senator Furphy.
Thank you, Mr. Chairman. let me understand this process. Okay, are you suggesting we contact the trucking companies or the factoring companies?
This wouldn't be just for us. I would suggest that you actually contact the major venture funding organizations and that you basically advertise the legal framework that you've already built in this state to the venture funding companies, that you advertise it to the angel groups, not just in Wyoming, but throughout the United States, that if they're going to fund somebody, that those companies really should be Wyoming-based.
Mr. Co-Chairman.
Yeah, and I appreciate the point. I see the point that this would be something for the Wyoming Business Council to effectively prioritize. And that is one of their roles and responsibilities, obviously, is to try and drum up business for Wyoming, get businesses located here. And we've heard similar concerns before where DAOs are a great example. We have DAO legislation. We have the entire framework to support decentralized autonomous organizations. We've got legal definitions for property in the state of Wyoming associated with digital assets. We have everything you need to effectively run a DAO. Most DAOs are still incorporated in Delaware. And they don't even look. Right? It's just, where do we incorporate? The answer, Delaware. Okay, we'll incorporate in Delaware. The fact that they don't have any legal framework to effectively address how a DAO would settle transactions, that is seemingly of no consequence. Marketing's not something Wyoming does very well, honestly, and we don't put a lot of resources towards it. It is one of the reasons why Delaware leads. They have a marketing budget for corporations, and even Nevada markets the hell out of their corporations division, and I think we outperform Nevada, but we just don't market to it. So the discussion before had focused more on how do we get attorneys that are working with companies to incorporate, to recognize Wyoming's strengths in this space. But I think the tack that you're bringing is an interesting one that is worth chatting with business counsel about, because I don't think they've done it, which is, well, it's not just the attorneys that make that decision. It's literally the angel investors and the Series A folks and early capital investors that help to shepherd. And I think that's a strong point. So I'm happy to bring that message to the business council, follow up with them, and start the conversation. I think it's a really good one. They should have the resources already to do that, honestly. Not to say they wouldn't accept more resources. They always seem to be willing to accept an appropriation if offered. But I think even just prioritizing that. So we will follow up on that. I will follow up on that.
Yeah, and if I could, Mr. Chairman, just to draw one quick analogy, I live just north of Cincinnati. And I remember when the state of Michigan came out with their Pure Michigan campaign, right, to drive ecotourism, and they really made a ton of headway with it. Now, that was more of a government to consumer type proposition, but if the state of Wyoming could kind of, maybe focus on a theme that's specific to institutional investors, attorneys, folks in that space, I think it could do a great deal in terms of advancing not just the value proposition that the state has created from a regulatory perspective, but driving in that revenue that I think everybody in Wyoming wants to see.
Mr. Chairman, quick follow-up. The interesting thing here is, and this is what's very different from trying to find all the attorneys in the country and get a message to them, is what you're suggesting is it's like 100 people or so. 200 people would be meaningful if you had a targeted marketing campaign for that many people that are known to be working on venture capital in this space or active in this space, which honestly should be very achievable even from a saturation standpoint. We should be able to hit them pretty hard. So thank you for that suggestion. I think it's really valuable.
Committee, any additional questions for? Yeah.
So I do have a question, getting back a little bit to Jake and I met prior to the last big presentation at the national group for this trucking industry. Can you give us a little bit more detail on kind of how that went? You said that it was applause, but I'd just like to hear anecdotally a little bit more about what the path forward looks like as a result of the connections you probably made there.
Sure, that's a great question. So we obviously get a number of questions about adoption. You know, are the trucking companies really going to be able to figure out how to take settlement in a crypto wallet and then get back to USD liquidity? Is the will there? Is the acumen there? The interesting thing that we found, though, is, you know, you think about a lot of these truck drivers, they're in a cab 8 hours a day. Especially during COVID, they heard all of the ads for Coinbase and for Kraken, and a number of them have dipped their toes, and they probably have a better understanding of crypto in the aggregate than most of the American public, I would argue. The value proposition for the industry, though, is tremendous, though, because if we go back to that single owner operator, that person can recapture potentially up to $20,000 to $30,000 a year in net revenue. I think the industry average for a truck driver right now is about $60,000. So you're talking about potentially a 50% increase in annual salary using a blockchain solution as opposed to using the banking or intermediary solution that's out there now. So we have been approached. We continue to be in beta with the carriers that we have in our beta program. We'll be in beta most likely through the end of the year. Our hope is to be able to open the floodgates to this solution in early Q1, early January. But the most exciting thing I think that has happened in the wake of the presentation that we made at the Future of Freight conference is that we've been approached by all of these industry strategics who are already working with our customers, our future customers. They're working with 3 million of these customers, and they're looking at ways to integrate with us directly because they want their customers to be able to share in the value proposition that's, you know, has not been available in the market until now. So we're very excited. We have a lot of work to do, clearly, but we're excited and looking forward to the challenges.
And I always ask this of new company startups that present to us, any barriers that we need to be looking at that the state of Wyoming, for example, has created, holding you back, slowing you down, that maybe we could consider revising or improving. Anything we need to do.
Anything on that, gentlemen? The only thing that I will throw out there is we were advised that and I don't want to get the nomenclature incorrect, but the process of getting the equivalent of a non-enforcement letter from the Secretary of State, we were advised that the cost on that went up to $2,000. So not that that's a huge problem, but for a number of startups who are looking for a favorable jurisdiction to incorporate in, I think if there is a way to mitigate some of those front-end costs, I think that will make the state even more attractive.
Okay, Mr. Chairman, I made eye contact with our Deputy Secretary, and that's not her understanding, so we'll check in with her on that, but let's follow up on it and try and figure out the details of exactly what that is.
Got it.
Thank you.
Thank you very much.
Thank you. Great to hear from you. Thank you for being here.
No. Deputy? I'm curious now. Welcome, Deputy Wheeler.
Thank you. Good morning, Mr. Chairman, members of the committee. I can tell you that we do not charge for no action letters.
Sounds like that was a quote from an attorney.
Yeah, might have been a markup.
Yeah, there was. Was that my office? Because that seems low.
All right. Thank you, Deputy.
You're welcome.
Okay, thank you. Any public comment on TCS? None online? Any in the room? All right. Committee, let's go ahead and take a 15-minute break. We'll be back at 10:15. Welcome back, committee, from that break. Let me, for whatever reason, I decided to close my agenda. Thought I was done. We have next topic is Wyoming Digital Asset Registration Act, Bill Draft 23 LSO 0171. Mr. Hopkinson.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 23 LSO 0171, working draft version 0.5. The first thing committee may notice is the staff comment, which highlights a couple of important things. Primarily, it outlines the differences between this version of the bill and the version that the committee has seen in September, and then some potential considerations that the committee may wish to look further at. So just walking through those changes, the first one is that I'm going to take it a little bit out of order. It does allow, this version of the draft now allows for an agent of the lawful owner to register and not just the lawful owner. And that kind of leads into one of the considerations further down the road for the committee is, should there be any restrictions on that agent? Should it require it to be a registered agent? As drafted, it could be anybody acting on behalf of that person. And so there aren't any of those types of restrictions. And we see that first change then on page 3 in line 27, that it allows for the lawful owner of any digital asset or the lawful owner's agent may register. The next change was a some slight grammatical changes on page 4 in the, and working basically through lines 4 through 7, where it allows for someone to register a digital asset and they shall be deemed located within the state for purposes of all laws and regulations of the state or any applicable federal laws not in conflict with this article, which may impact ownership rights of the digital asset or require transfer of the digital asset. So this really is kind of the core of the bill as far as what it accomplishes, and that is that a digital asset would be deemed located in this state, but only if it's not in conflict with federal law, or and it also requires that it be a law related to the ownership rights of the digital asset or requiring transfer of that digital asset. New on page 4 would be subsection C. This simply provides that nothing in this article should be construed to confer any ownership, property, or other rights related to digital assets beyond those specifically granted in this article. This was kind of some cautionary language that was added pursuant to some conversations that I had specifically with Christopher Allen and Brendan Marr. It may not be necessary, but just kind of there for the committee's consideration, and to try and limit anybody attempting to expand the rights or being unclear as to what those are. On page, some of the other changes on page 5, there's a new paragraph 4, and this portion of the bill is going through what information is required or what the application for the registered digital asset would require. It would now require a statement that the lawful owner has control of the digital asset at the time of application. The next addition or change in this version is on page 6.
Senator Ruffus.
Thank you. David, on that last, the phrasing of it, that obviously gets into our UCC concept of digital asset ownership. Would we interpret, or would it be interpreted that is unique control? I think this is something we talked through before about if three of us have control over it. We all effectively have joint ownership based on kind of the digital asset concepts. I think that's how you laid that out to interpret. I'm really getting at just making sure that this phrase is consistent with the way that we did things in the UCC digital asset legislation. Any concerns there? I mean, I think it's fine. I think you don't have to have unique control. You have to have control, and that, based on our digital asset law, should make you an owner of it, but not necessarily a unique owner. Is that kind of how we're intending that to be read?
Mr. Hopkinson?
Thank you, Mr. Chairman. Chairman Rothfuss, I would agree that that's the intent, that that's how that would be read. One of the considerations for the committee that I highlighted in the staff comment is we may want to define that, just to be clear, or point to the proper definition. So that's certainly something for the committee to consider.
Yeah, that might be a good
if we
idea.
want that.
So is that defined in the other act that you're talking about?
Well, so in the UCC, we talk about control. Do we define control back in our UCC digital asset?
Primarily, we list what control may include,
Yeah.
but there isn't a clear definition of control is or control means. It's more along the lines of control includes X, Y, and Z.
We could still say a pursuant to, and then point back to UCC digital asset, our digital asset overlay on the UCC. That might be worth doing, just so that people know what when we say control, that we're really going back to the language in the UCC. Okay, thank you.
Next change is a new subsection D on page 6. If the applicant is a registered agent, pursuant to that would be the registered agent statute, the lawful owner of the digital assets shall provide the information required, and we'll get to that later on in the bill. But this is just essentially would require the lawful owner, if he's using a registered agent, to provide certain information to that registered agent. Another significant change is at the bottom of page 6 in paragraph A, or subsection A. This would allow, upon the filing of a complete application for registration and payment of a registration fee, the application shall be deemed approved and the digital asset registered pursuant to this article. One of the requests the committee made was to have kind of the process be a little more automatic and discretionary for the Secretary of State. If they wanted to take a further look at an application, they could, and these changes would allow for that it would be deemed approved and registered unless the Secretary of State at his discretion causes the application to be examined pursuant to those paragraphs there. And those are the same as were in the previous bill, that the Secretary can request additional information and have kind of a dialogue with the applicant and ultimately reject it if they fail to respond or fail to meet all the requirements of the application. Next change. In the 3429-206, we did eliminate, in the original version, there was the option for assignment of the bill and also an option for change of name. This version eliminates the option for a change of name, as that seemed to be incorporated already by assigning the right to another individual. And so that section now just provides for the assignment of the right to another person, or of the registered asset, the registration to another person. Next change on 208, on page 10, subsection A1 allows that the cancellation can be done by the lawful owner. Just to clarify that. And then
on the cancellation, we have the earlier registration by a third party. And we obviously have to still chat about registered agent versus not registered agent. Could this cancellation be by a third party also as written? Or would the primary owner have to be the canceller?
So,
Mr. Hopkinson?
Mr. Chairman, that paragraph would read that upon a voluntary request from the lawful owner or his agent. The lawful owner's agent could cancel.
Line 8, there we go, thank you.
That's not necessarily a registered agent.
As written.
That's just
Yeah.
agency.
Correct.
Yeah.
And then the final kind of major change to the bill is on page 13. It brings in the registered agent statute with an additional paragraph that would require a registered agent to maintain at their office information about the lawful owner, including the lawful owner's name and address, the lawful owner, or the name and physical address and business telephone number of a natural person who's authorized to receive communications from the registered agent on behalf of that lawful owner, and a copy of the written contract or agreement creating that agency relationship between the registered agent and a natural person with respect to accepting service of process on behalf of each lawful owner, represented by the registered agent.
And I assumed when reading that that was effectively mirrored language for all the responsibilities they have as a registered agent for other instances where they're acting on behalf of a LLC or whatever else. Is that fair?
Mr. Chairman, Chairman Ralphus, that's correct. Okay. That language is mirrored. And then the other final changes to the dates, and this would have the Secretary promulgate rules not later than October 1st, 2023, with an effective date of October 1st, 2023 for kind of the bulk of the implementation, and an immediate effective date simply for allowing for the promulgation of rules. Some considerations for the committee then that I just wanted to highlight. Again, going back to, should it just be a registered agent? Should the registered agent have additional obligations? For example, one thing that came out in discussion was perhaps requiring a registered agent to verify that a lawful owner in fact has control of a digital asset. So that's a policy question for the committee. As drafted, I would note that the application does require whoever applies to assert that, or to have a statement in there that the lawful owner has control of the digital asset. So in a sense, that may be a condition as drafted. So again, policy consideration for the committee, if they want them to have to do that or not. But that would apply to any agent who is doing that, not just to a registered agent. One other area, again, for the committee is whether a registered digital asset applies just to a single unique digital asset, or if it should apply to a kind of a basket of digital assets. I do think that may be a little unclear as drafted, given that in Wyoming statutes, the plural can be singular and vice versa. So the committee may wish to clarify its intent there. As drafted, it does require that information be publicly available, that there be a registry kept that someone could look at as far as the registered digital assets. It does not spell out what specific information would be kept. And that's in 3429-207, newly created. The committee may wish to consider specifying what information could be kept there. And then finally, just to note again that this draft would waive the $50,000 minimum threshold in order to be heard in the Chancery Court. And so as drafted, the Chancery Court would need to hear issues related to registered digital assets regardless of their value. Again, policy question for the committee to consider. With that, I would stand for any questions on this draft.
Committee, questions for Mr. Hopkinson? Representative Stith?
Mr. Chairman, Mr. Hopkinson, I think this question may be similar to my question at the last meeting, and I haven't made any advance in my education or understanding of it. What's a concrete example, if you can think of one, where this would be really useful for someone to be able to register a digital asset? Is it going to be, I don't know, like Nike's virtual sneakers, NFTs or something? Or when is it going to make sense to do this? Sort of where's the, from your point of view, the value added of being able to register a digital asset?
Mr. Hopkinson?
Thank you, Mr. Chairman. Representative Stith, as drafted, the primary value is seen in 3429-202A, that for purposes of Wyoming law and any federal law that's not in contradiction, the asset would be deemed to be located within the state of Wyoming. So what you're really getting is access to Wyoming's courts, and particularly potentially the access to the Wyoming Chancery courts for a swifter resolution. So it really only applies to when there's a question or where the location of the asset is a concern. That's what you would gain by registering as drafted.
Any other questions for LSO? Sure. Yes, Mr. Co-Chairman.
Well, I just start off by saying I really appreciate the revisions on this. It's a great job, David, getting all of the discussion captured from last time. One thing that I was trying to remember is our discussion around agent versus registered agent. And I guess I'll ask you for your recollections, but maybe as we take public comment, this is a common theme. It seems that we have a pretty good infrastructure built around the concept of a registered agent. It's understood how that works, and maybe we need to modify that moving forward at some point for digital assets better, but at least we've got a good construct people understand. Do you have any ideas, what else would an agent be? I mean, it sounds like it could just be anybody acting on anyone else's behalf, which might then be a little bit confusing. And I don't even know how you would then track down if you needed to serve process. You could get several layers deep in this. Did you see a value or have maybe anyone else in the committee see a value at this time of us going with agent as opposed to registered agent?
To me, I'm confused on why it would even be necessary to be in statute. I think if the opposite were in statute, that you couldn't do it by agent, that would make sense. I don't think you have to specify that the owner may cancel or his agent. I could theoretically, I believe, I could give that power away through an agency, through a power of attorney to whomever I want to transact on my behalf, unless the statute specifically prohibited me from giving that agency. So I don't see the value in that. But as for the registered agent, there would be a value in that, because if there were forms contemplated by the Secretary of State's office for cancellation, they're gonna only accept it if it's signed by the owner, unless the statute says it may be signed by a registered agent. He said, Representative Stith?
Mr. Chairman, I also want to thank Mr. Hopkinson for his work on this draft. I think it looks really good, frankly. I don't think from my point of view, I think leaving the language as it is better. I don't think we want to limit this ability to register and to cancel just to the registered agent, because then I think that would gum up the process. Because if let's imagine you're the vice president Nike in charge of NFTs, and your registered agent is XYZ Corporation with a PO box in Cheyenne. I think Nike wants to be able to just do it on its own and register it without having to make it, get its registered agent on the phone. So I think limiting it to the registered agent to me would be problematic. I think agency is a pretty well-developed idea that's really not ambiguous. People can dispute about whether you really are the agent, of course, but I think it would gum up the process to restrict this to registered agents. So,
I just don't, maybe we could ask the Secretary of State what they think this would look like, but I would envision, again, there's a form, And if I'm, most likely Nike, Nike's president isn't going to submit the form. He's going to he's going to have an attorney who just collects his signature on the form and submits the form, right? So where's the scenario where you would want, what I'm concerned about is if you're specifically allowing for an agent to cancel, then the Secretary of State, when it receives a form that's signed by somebody else, how is it going to know if that person's the owner or the agent? They're not going to know. It's just going to be a signature on a piece of paper, right?
Mr. Chairman?
Yeah.
Well, I think we already have that issue in the law. If you do a UCC termination statement, right, for example, or a UCC filing right now, we don't require that the registered agent of the corporation is the only one who can do that. Anyone within the company is authorized to do that. And theoretically, it's possible for someone to fraudulently file a UCC, make a UCC filing, or fraudulently try to terminate a UCC statement. I think that problem of malfeasance and fraud is not one that we can solve here. And I think it would be overkill to restrict it only to a registered agent, because then you have the other question of, well, is this person who says they're acting on behalf of the registered agent, are they really authorized? I don't think we need to, I think the language works as it is.
Yeah.
Well, I would say that I think the intent would not be only a registered agent. It would be the owner or the registered agent. For the Nike example that you mentioned, if you're signing as the owner, effectively, which is what you would be doing, right? You would be Nike signing that. If you had authority within Nike to sign off on the termination, then you're the owner signing it, acting on behalf of the corporation. Do you see an example that kind of goes outside of that, where you would want an agent that isn't a registered agent to be acting on behalf of the owner that isn't truly the owner or isn't legally deemed the owner?
I would see it as your attorney, would be the scenario I would see. Where if you're Nike, you're probably not using a registered agent shop, you're probably using a law office. And my concern is what it would portray based on the signature. Would that person be able to portray themselves as the owner? Would it be evidence that they are the owner? Would they think that they're, I've seen this with LLCs, because we allow an incorporator to file. So anyone can file who's not actually the owner of the company. It's the incorporator can be a complete third party, essentially. And I've seen confusion where an incorporator believes that they own the company because they signed that document. And then when you go to the Secretary of State's office, they don't know who signed. They don't know who has authority. They just have a form with a signature. So this provision of the statute, how would you check the cancellation? You wouldn't. It says it can only be canceled by the lawful owner. There's just no check then, because the Secretary of State's office is going to probably accept any document that's signed, period. So it's almost pointless.
Mr. Chairman, when you look at the U.S. Patent and Trade Office and filings for the USPTO, you certainly have an explicit owner list that is public. Who are the inventors? Well, you've got an inventors list, and then you've got an assignment owners list, and then you also then have attorneys just making filings on that, where there is an on behalf of authentication process. So to some degree, there's a registration, but obviously they've got a pretty detailed and built out system there, but that's how that operates. So you have a series of different, same thing with a registered digital asset. We are going for ownership, but there actually is a creator side of it also. We don't have that in this draft. There's a creator, potentially owner. We're just looking for the registration of the owner. So is your conclusion that we're okay with the language as it is right now, just leaving an agent? Or it sounds like that's what Representative
Yeah,
Stiff is comfortable with. You're comfortable with it as it is now?
Yeah, my position is it doesn't have to say agent. I think that agency law is already covered there without it, unless, that's what I'm saying, unless it expressly prohibits an agent from signing it. I don't think there's anything in the statute when it says a lawful owner that would prohibit me as a lawful owner from giving the authority away to whomever through an instrument to file on my behalf. I think you could already do that. I think it's fine to leave it. If Representative Stiff likes it, I like it. Okay. All right. Yep. Any other questions for LSO? All right. Thank you, Mr. Hopkinson. Secretary of State's office. Welcome, Deputy Wheeler. Back to the table. Welcome, Mr. Secretary.
Thank you, Mr. Chairman. Appreciate the chance to be here and speak on this bill to you. Got a few comments first.
Mr. Secretary, sorry, you got to, just for the record, you got to still introduce yourself. That's all right.
Carl Allred, Secretary of State.
Thank you.
Thank you. I usually do that, and I'm sorry I forgot. Hey, as we get started on this, I've got a few thoughts, but Deputy Wheeler has got a pretty comprehensive information she'd like to present, so I would defer to her at this time.
Absolutely. Deputy Wheeler.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. Karen Wheeler, Deputy Secretary of State. First of all, I'd like to thank Mr. Hopkinson for his revisions on the bill. He did incorporate the amendments that we had requested at the last meeting, and I greatly appreciate it. Mr. Chairman, the concern that we have in our office is when you bring the registered agent into it. So first of all, being able to define what an agent is versus a registered agent. If you're going to use both those terms in this legislation, our customers will get confused because they will see agent and registered agent and think they are one and the same. So I would just say maybe if you can find another term for agent so there is not confusion with our customers. Or a representative or something. So first of all, I think in reading through this, to incorporate a registered agent in here to be an applicant, again, given confusion that I know we'll see from our customers, if the intent is the registered agent be a Wyoming registered agent, I think you should state that in here, because I can see a customer who is not familiar with Wyoming law thinking, oh, I've got a registered agent in Nevada, I'll just have him do this. So if your intent is that it is a Wyoming registered agent, I think that we should clarify that. Additionally, as you're looking at having a registered agent be the applicant, I think it might be helpful to understand our registered agent industry in Wyoming. So as of this morning, right before I came down, we have 589 commercial registered agents. They represent more than 10 business entities. These 589 commercial registered agents represent 282,782 of the 339,090 active entities in Wyoming. So there's only a little over 56,000 business entities that are represented by a registered agent who represents less than 10 entities. So based on the patterns that we see with entity filings in our office, I think it is very highly likely that if the registered agent is the applicant, it's going to be one of your commercial registered agents. So they won't really have the tie to the owner like I think the intent is. So I just want you to be aware that that's probably what we're going to see. Additionally, Chapter 28 of Title 17, the Registered Agents and Office Act, that is the relationship between a registered agent and a business entity. So if we are going to allow a registered agent to be the applicant, and as you saw on later in the bill, that you are putting provisions in the Registered Agent Act that the registered agent must now keep additional information, then I think we have to look at the Registered Agent Act as a whole to modify changes in it to reflect. So for instance, when an entity forms with our office, they must submit a consent that the registered agent has signed, and the registered agent consents to be their registered agent. When they file online, and the majority of our filings are online, as soon as our system sees that consent, it automatically sends an email to the registered agent. Did you consent to be the registered agent for this entity? Many times we get what is called a denial of consent from the registered agent saying, no, I did not. So if we don't have those same provisions for the digital asset, given that more than likely it's going to be one of your commercial registered agents that files as the applicant, I think you need to maybe tighten that down, that the registered agent has given consent to be the applicant, or that the owner has given consent to use the registered agent. Additionally, Mr. Chairman, in the Registered Agent Act, if a commercial registered agent is made inactive because they have failed to renew, or they did not comply with an audit that our office did and pay the fines that we have assessed, they are made inactive and they cannot be used. So I think we need to build those safeguards in as well. Also, if a commercial registered agent changes their name, changes their address, they file a form that is applied to every one of their entities. But if we don't somehow bootstrap this into the Registered Agent Act, a registered agent changes their name or their address, it will not be reflected as the applicant on this application. So those are just some of the thoughts that I have in looking through this and incorporating a registered agent as the applicant.
Deputy Wheeler, as to the registered agent versus the Wyoming registered agent, is it sufficient enough that in 1728-101 for a registered agent, we define it as a resident, someone who resides in the state? Or would it just be, if that's not sufficient, I suppose we can just reference back a registered agent as defined by, because I don't think we use the terminology Wyoming registered agent anywhere. We just define it as the person or entity residing in Wyoming. Is that accurate?
Mr. Chairman, that is absolutely accurate. When you look at the definition of a registered agent in 1728-101, it is, they are physically located in Wyoming.
So maybe just a reference back to when we mentioned it the first time in our bill, we would just say as defined by, or do we do that, Mr. Hopkinson, already?
Mr. Chairman, it does not, but
That's pretty
it would
easy.
be fairly straightforward to add that definition in the 3429-201 and just point to the definition 1728-102A.
Perfect. Okay. Representative Stiff?
Mr. Chairman, Deputy Wheeler, on page 6 of the bill, lines 11 through 14, we have the provision that says if the applicant is a registered agent, the lawful owner, et cetera. In your view, would it be cleaner and simpler to just delete lines 11 through 14 and delete the other references about registered agents from the bill and just have the bill say, if you're an applicant, you have to be the owner or an agent of the owner, and just leave it at that? Would that be simpler from your point of view?
Deputy?
Thank you, Mr. Chairman. Representative Stitt, if you are going to leave it as the owner or an agent of the owner and remove, that agent is not a registered agent, then I think you will be alleviating a lot of changes and modifications that you would need to make to the Registered Agent Act.
Mr. Chairman, can I follow up on that?
Yeah, Co-Chairman Office.
Do you see different challenges and different problems as a result of that? Or do you see that being a streamlined, effective solution that achieves what, I mean, you know what our objectives are here, and we're obviously trying to make it as business-friendly, user-friendly, and agency-friendly as possible. So is that just a different series of train wrecks, or what are your thoughts?
Deputy Wheeler?
Thank you, Mr. Chairman, Mr. Co-Chairman. So keep in mind, first and foremost, business filings in our office, our role is ministerial only. So if you remove all this and you leave it just as the agent, it's ministerial. We file what is required to be on the application. Where it gets complicated is when you bring in that registered agent component to it, because it affects then what a registered agent does. So for instance, the language on page 6 that we just referenced, the information that has to be provided to the registered agent is for when our office audits the registered agent. And if the registered agent does not have that information, they are subject to a fine of up to $500 per instance. So what the customer will see on the front end, whether you have a registered agent or not, they won't know. Where the impact is the registered agent that is signing on as the applicant.
Senator Office.
And I realize it's not a perfect analog, but looking at our trademark law, do we have any special provisions for registered agents for our trademark registration for the state, or is it effectively by the owner and registerer, which would be similar to what we'd be looking to if we removed registered agent?
Deputy Wheeler?
Thank you, Mr. Chairman, Mr. Co-Chairman. The bones of this particular legislation is based off of the Trademark Act. The Trademark Act does not have a registered agent in it.
That's useful.
Additional questions for Secretary of State's office? Okay. Are you, okay, I wasn't sure. Go ahead, Secretary.
Thank you, Mr. Chairman. A couple of things just to consider. I mean, you know, if you want just an agent, as has been spoken about, that could be anybody. And then you really don't know if they really are the agent or not. They're going to have to prove that. But the one advantage of using a registered agent is because then they have, if there's an issue that arrives over that, there's somebody that accepts process. If you're just using an owner's agent, that could be somebody in Georgia, and that'd be a lot harder to track down, where a registered agent has to have an address where they can accept process here in the state. So again, that's up to you guys, which way you want to go with it. There's advantages on both sides, but I agree that if you're going to take it out and just allow agent, then I'd remove that section on page 6. And then in that case, if you do that, then you can remove all of the additions to 1728-107 and remove that for there.
Yeah, I think that's a really good point, and I think there's definitely a policy choice committee, because I also think we've got this list of required information that a registered agent would have to keep in-house to produce when audited. But the advantage of using an agent, who is your attorney, as opposed to a registered agent, is that I think there's a huge argument over whether any of that information would ever be produced, because it could be attorney-client privilege. So that's a policy question if you leave agent in. If your purpose is to strengthen the state's ability to access that information, you don't want to say agent, you want it to be a registered agent. If your policy position is to strengthen privacy and anonymity, then you want to leave it in.
Just.
Go ahead,
Mr.
Secretary.
Chairman, a couple more questions. Like I say, that one's up to how you guys want to deal with it. But I would concur with the LSO's recommendation. The reference to the Chancery Court, the way it's written right now, it's wide open. I mean, it could be small claims, could go into that and bog up that Chancery Court. I would believe if you don't want to have 50,000, but that you put at least some reasonable amount in there, that just a thought, that was a recommendation from the LSO on that. And then last thing that I wanted to bring up on page 5 at 15 to 19 there, as far as registering this, they have to do a statement, applicant is the lawful owner or the owner's agent, and that to the knowledge of the applicant, no other person has a current valid registration. Now, I would think that it might be better to go, no other person has a valid ownership claim. Because they may own that digital asset, but they don't have it registered. This is kind of new, registering these digital assets. And it just a thought there that maybe you go to a valid ownership claim versus, that they're signing that statement. Because I may know that you may not have it registered, but it's yours and I'm going to go register it. So just a thought. And any other questions?
Questions for the Secretary? No? Representative Stith?
Mr. Chairman, one final follow-up question.
Yeah.
For both the Secretary and for Deputy Wheeler. Under our current trademark registration scheme, do you have any administrative difficulties right now?
Mr. Chairman,
Deputy.
Representative, no, we do not. And Mr. Chairman, if I may, I did want to remind the committee there is a fiscal impact on this bill.
Of course.
And I did mention it at the last meeting, but to build a new online module to our existing system to do this, the fiscal impact was $248,400. Now, if you incorporate the registered agent aspect, that fiscal impact will change as we will have to add additional modifications.
What is the fee to register? I saw $30 to cancel. Is that what it is?
Yeah. Mr. Chairman, in there it says not to exceed 300.
Okay.
So depending on rules set up on that fee schedule, but not to exceed 300.
And do we have an appropriation in this? Do we want to?
We
do not. I mean, if we know it's going to cost the $250,000 to build this system, then we could just appropriate that straight out of the LLC income, right?
Yeah, out of their income.
Borrow from rather than it go straight to the general fund, we just borrow $250,000 from it.
Well, Mr. Chairman, the end of every day, when we receive all the funds, it goes directly to the general fund. It doesn't even stop.
Right.
We'd have to do a holding account like we've done in the past.
Yeah.
But
It just always, I always feel better when it doesn't say general fund. Appropriator Stith.
Mr. Chairman, I think it's a good suggestion. If this is going to cost money, let's be upfront about it. Let's go ahead and appropriate the money and just have it be general fund, because Secretary of State's office doesn't right now really have special revenue accounts. It just all goes to the general fund. There's a certain transparency to that.
Okay. Now, when I take this bill in front of the Appropriations Committee and they say, why is it general funds? I'm going to look right at you.
Yeah, that's exactly right. And then it gets stripped out.
And I've
Mr.
moved to
Chairman?
$1. Yes, Secretary.
Thank you, Mr. Chairman. One other thing, as Deputy Wheeler mentioned, there is the cost of building this to do it. But just to throw a little tickler in your mind, The employees in our office are overworked, strapped. This will increase that, and quite frankly, to increase the workload that we have, and I appreciate comments that were said about throwing some more work our way, but we need some more employees if we're going to be doing this. They're completely bogged down. I mean, as far as what they have, they're getting the work done today, but if we're going to increase that, it is, and I hate to say anything about, increase, you guys know me, increasing the size of government is be the last thing I ever say, but the workload would have to be managed.
Deputy Wheeler, you did not mention that in your fiscal note.
No, Mr. Chairman, I did not.
So what, give us an idea of what specifically the workload would be required to efficiently carry this out? Is it an FTE? Is it 3 FTEs? What is it?
Mr. Chairman, I would love to say 1, 2, 3, 4 of them, but I don't know the volume we're going to get.
Right.
I mean, this is new, and I will, and thank you, Secretary Allred, I greatly appreciate it. Our business division is 11 people.
Okay.
And I'm just going to give you an idea. I have some stats for you, because I always give you updates.
We'll try and stump her today.
There we go. So just, I always tell you how many LLCs we have formed at the end of when I tell you your stats. Just from July 1st to November 15th, we've had almost 41,000 brand new LLCs formed. Wow. Now, while the majority of them are online, and that is efficient for our customers, it creates a huge workload on the back end for all of our registrars in there. In addition to the 4,000 phone calls they personally answer each month, in addition to all the voicemails they return, in addition to the 5 email accounts that they personally respond to, and in addition to the 117,000 paper filings they do a year. So with the workload right now, yes, it is heavy. They are buried. Having additional personnel would be wonderful. Can I tie it directly to this? I can't, because I don't know the volume we'll get.
Yep, that's just really, I think that's fair. I want to anticipate if there's going to be a fiscal note coming from the Secretary of State's office when this bill is finalized that says FTEs. I'd like to be ahead of that, but it doesn't sound like that's going to happen.
Mr. Chairman, in all fairness, this is my last meeting. I will not be there when this bill goes to the Secretary's office for fiscal impact. So I cannot guarantee that it will or will not be there.
Mr. Chairman.
Secretary Allred, we're gonna have you write a big, beautiful note to Secretary Gray that when he presents this for the supplemental budget that he needs those positions.
I will inform him of that, Mr. Chairman.
Mr. Chairman.
Go ahead.
And those new, I think you said 41,000. So what is that? That's about 2.4 million of ongoing revenue every year in renewal fees, even after the initial registration, assuming that they don't terminate. Is that about right?
So, Mr. Chairman, Mr. Co-Chairman, the 41,000 is excluding Dows and Series LLCs.
Well, why would you ever exclude those?
Well, because I thought you might want to know.
Because we like to hear the Series LLC numbers separately.
That's true. We would like to hear those numbers separately, please.
I just happen to have them right here.
Great.
So, Mr. Chairman, as of November 15th, there are 484 active Dows.
Wow.
There are,
100 since the last time.
last time there was 357.
Yeah.
You are up to 484. There are now 98 inactive. Last time there were 28.
Okay.
So of the 98 inactive, 21 were administratively dissolved for failure to file the annual report. 1 was administratively dissolved for failure to maintain a registered agent. 8 chose to dissolve themselves. 23 were administratively dissolved for not having a public identifier, and again, they are given 30 days to provide that. 44 were voided for deficient articles. Again, they were given 30 days to correct those deficiencies. 1 was voided because they presented an NSF check on the filing. Of your Series LLCs, we have 877 active series. We had 859 in September, so we've gone up. The 877 represent 14,752 established series. Of the inactive, we have 255 inactive. 192 did not file annual reports. 41 filed articles of dissolution. 19 did not maintain a registered agent. 2 foreign series LLCs withdrew and 1 transferred to another state. I gave you the LLC statistics, and still, as of today, we have 51 utility tokens filed, and 14 of those were since the new fee went into effect.
Really?
There is my last statistical update for you.
Well, thank you.
Oh, and Mr. Chairman, just for you, Chairman Rothfuss, July 1st to November 15th, there were 2,924 entities dissolved or they withdrew.
Thank you. Perfect. Thank you so much. So differential of 38,000 increase. That's awesome.
Committee, any other questions for the Secretary of State's office? No? All right, very good. Thank you, Mr. Secretary, and thank you, Deputy Wheeler. Is Christopher Allen online? Can we bring him in? Any other public comment online?
I'm here.
Go ahead and bring Brandon in as well. Any public comment in the room on this topic? Raise your hand if you're going to comment on this topic. Okay. All right. So to stay on task here, we do have just a few minutes, so let's keep our comments to the point and brief, please. Go ahead, Mr. Allen.
Thank you, Mr. Chairman, co-chairman, and select blockchain committee members for inviting me to participate. I also wanted to thank LSO David Hopkinson for our dialogue on this bill. My name is Christopher Allen, and I'm the founder of Blockchain Commons, a blockchain infrastructure development and research organization. Over the last getting close to 5 years, I've been quite proud to witness Wyoming through the initial blockchain task force and now this select committee to become a leader in the area of digital asset technology and regulation. It is because of laws successfully begun at these meetings that I have established my organization Blockchain Commons to be domiciled in Cheyenne, Wyoming, and have encouraged other companies to do the same. In regards to this legislation, I believe it is quite important, and a decade from now, it may be considered, like the LLC, to be one of the most pivotal laws in the emerging digital world. A number of the changes that I suggested to David Hopkinson, he's already incorporated in today's draft, but I really feel like there are a number of areas that he could not do because he needs guidance from this committee. In essence, this law enables a person, whether natural or corporate, to have judicial clarity for digital assets by defining a jurisdiction for an asset that otherwise could be anywhere on earth, right? It can be in any state, any nation, or whatever.